And so, for the courtesy to your fellow participants, please turn your cell phones off.
Rich, I don't know when it's going to get here, but I've asked, we've got an easel and a big flip chart coming where you can make
Yes.
questions and things, so that's coming. I just don't know when it'll get here.
Yeah, I suspect you guys are going to challenge me with some unusual organizational relationships. And in some cases, I'm going to want to draw, make sure that I understand the questions that you're asking, because it may have some impact on the proper financial treatment and responses to those questions. So who are these people at OMB? How come we've never had a training class on this stuff before? And why do I need to know this? Just by way of background, the predominant role of OMB, they're basically based in the White House. They're not an executive, they're part of the executive branch of the government, and they have oversight over what are known as executive branch departments. And these are all the departments who give us money. It's HUD, it's DOT, it's HHS, it's Department of Labor, it's Veterans. There's about 13, 14 different agencies, and these are likely to be the agencies that provide all of the grant money to your organization, are likely to be executive branch departments. OMB sets the ground rules on how they give out money. Now, Congress gets involved in this process as well, but for the most part, it's OMB's responsibility. And their responsibility is channeled into three key areas. Cost principles. And in plain English, that means what we can and cannot charge to a federal grant award. OMB determines that with congressional input. The second area is grants management and administrative requirements. How do we close out a grant? How do we dispose of a vehicle that has ended or has gone beyond its useful life? Those procedures that virtually everybody uses, including FTA, are grounded in OMB regulations. And then finally, how many of you are subject to A133 single audit requirements? Raise your hand. Only a handful, unusual. The guidelines that the auditors follow in that process are dictated by OMB, not FTA, by OMB.
Rich, why don't you tell us what the threshold is for that?
All right, it moves. The threshold moves, and it moved in 2014. At one point in time, it was $300,000. And then in the late 1990s, it moved to $500,000. On December 26, 2014, it moved to $750,000. And essentially, if your organization expends from all federal sources $750,000 or more in your fiscal year, you are required to do an A133 audit. And your selected audit firm should come in and run a series of tests as part of his initial work development to try to make sure that the engagement is properly structured, because if you're required to do an A133 audit as opposed to just an audit of your financial statements, the auditors are going to want to charge you more money. And they should, because they have to do a lot more work. So some of the mistakes that I see is people count the wrong period. The $750,000 is measured in increments defined by your fiscal year. Not the federal fiscal year, not the state fiscal year, but whatever year your organization has adopted. The $750,000 is not measured just by your FTA funding, but it's all federal funding. And it's not what the grant amount says, it's what you've spent during the year that triggers the threshold. So we may get grants for $1 million, but if we've only spent $600,000, we would not trigger the single audit requirement. It's how much we expend. The universe of federal grantees encompasses about 39,000 different organizations. OMB found it difficult to carry out their mission in those three core areas of responsibility without making a little refinement. And that refinement is we'll develop guidelines depending on who we're talking to. And the first group or audience that OMB addresses are state governments, local governments, and Indian tribal organizations. The second group are IHEs, or institutions of higher education. And then the third group are private nonprofit corporations. And in prior periods, OMB would develop tailored guidance for each of their three areas of responsibility. So if you were a public agency and you wanted to know what I could and could not charge to a federal grant, I would want to look at A87. If I was a private nonprofit senior center, I'd have to go to A122. And if I worked for a university, I'd go to A21. Under administrative requirements, OMB lumped universities, colleges, and nonprofits together, and the guidelines were in OMB Circular A110. If you were a state, local government, or some instrumentality thereof, if you wanted to know about administrative requirements, you would use OMB Circular A102. And then, because each grant program had so many unique rules that each federal agency had promulgated in the execution of the enabling authority provided by Congress when it created a program, OMB found that it could not dictate everything that you needed to know to manage your grants. So what they decided to do is that we'll lay out the ground rules for grant administrative procedures, and then we'll let each federal department issue their own supplemental guidance that augments our baseline and tells you what it is you need to know. So the OMB guidance generally became known in grants management circles, and how many of you have ever heard the term the common rule? That's what we're talking about in this line. Fat fingers on this, forgive me, on this line here. And USDOT issued its version. Our DOT requirements on top of the OMB requirements in the Code of Federal Regulations. So if you were a public agency, you wanted to know about grant administrative requirements, you had to look up 49 CFR Part 18. If you were a nonprofit, historically a 5310 recipient, you would look up the same set of guidelines in 49 CFR Part 19. With respect to, yes, question.
Rich, we've been getting the Title VI plans updated by our subrecipients, and I've noticed a couple have come in and say that the rural transit system, while it's a county government, it is organized as a private nonprofit. Warren County and Catoosa, two that I know of, there's probably a lot of others, and that was news to me. So,
Okay.
A87 or A122?
That's actually a very good question, and there are about 6 sub-questions embedded in your question. We tend to have cascading grant relationships in transit. And one of the things that I strive for is to try to get uniformity and define the organizational relationships. FTA is the grantor agency, GDOT is the primary recipient. Whoever GDOT enters into contract with is a subrecipient. If that subrecipient enters into another lower tier agreement, That entity is a lower tier subrecipient. With respect to OMB guidance, you play by the rules associated with your organization. So under this scheme, even if I'm a nonprofit senior center that ran the rural transit program in my county, but I got the money from county government because that's who GDOT gave it to, I would play by the rules of the nonprofit organization in my financial management, grants management, and audit activities, even though I got the money from the county. There are, however, some rules where you have to abide by the rules applicable to the primary recipient. The Americans with Disabilities Act is one of those regulations where you stand in the shoes of the primary recipient of the grant funds. So, and the intention there is that you could not contract away your ADA obligations as a public entity by signing a contract with a nonprofit to operate your fixed route services, because the ADA complementary paratransit requirements only apply to public agencies operating fixed route service. So depending on the rule, with respect to Title VI, which was at the heart of your question, you would, there is no distinction in FTA guidance, which I believe is FTA Circular 4702.1, in terms of the organizational status of the recipient of FTA funds. Everybody prepares the same Title VI program, and because of what Congress dictated in passing the Civil Rights Act of 1964, it cascades down to every level. Here's a circumstance where the federal dollar never loses its identity. So if the state gives it to a county, Title VI applies. County gives it to a lower tier subrecipient to operate, Title VI applies. If the entity contracts with First Transit or NV or some other third-party operator, Title VI applies. That's not the case in every rule. It varies by the individual rule. But with Title VI, it cascades or flows down to every single entity that puts its hands on the grant dollar. The federal dollar never loses its identity with Title VI or civil rights, usually. So I hope that answers your question. So we've got a basic understanding of OMB, who they talk to, and what the rule books are, depending on who you are. Now, forget about everything I just said, because that's all gone. A date that shall live in infamy, December 26, 2013, is a date in the Federal Register when a group known as the COFAR, the Council of Financial something Reform, published under OMB sponsorship what the accounting industry refers to as the super circular, which isn't a circular at all. It's embedded in the Code of Federal Regulations, which basically has a higher level of importance than a circular does. And like I said, for lack of a better term, because they combined multiple what had been previously referred to as circulars, everyone in the industry has called this the super circular, even though it's not a circular at all. The formal name, not very inventive, administrative requirements, cost principles, and audit requirements for federal awards. And it's codified at 2 CFR Part 200. So if that rings the bell, people are talking about the super circular. I usually use the term super circular when referring to these rules. Some accountants may be a little more formal and refer to this as the uniform guidance, or the UG. So if you hear any of those terms, the party you're speaking with, the party you're talking to, is referring to the super circular, 2 CFR Part 200. And basically, it just wiped out everything that used to be there, and it's now all under one umbrella. Whether you're nonprofit, whether you're a public agency, whether you're a transit authority, whether you're a university, whether you're a hospital, you go to 2 CFR Part 200 to get your answers. It was published December 13, day after Christmas. There was a 1-year lead-in period. Most of us at the local level didn't do a lot during that 1-year period. It was at the federal level where all the work had to occur. Every impacted department had to get back to OMB by June 26th to say and let OMB know if there was anything in the enabling legislation or anything that Congress had done that was unique to a program that you were responsible for that was contradictory to the super circular. And OMB would review it and either give you the blessing to continue doing business as usual because Congress does supersede and override OMB. And all of those exceptions to the super circular were published in the Federal Register on December 19th of 2014, about a week before the effective date of the super circular. USDOT took its submission to OMB and codified it at 2 CFR Part 1201. So that will be FTA's exception to the super circular. The good news for us in transit, even though that particular day's Federal Register was about that thick, looked like a telephone directory, the US DOT exceptions to the super circular are on a page and a half. They didn't take many exceptions. Do we have any recipients of 5307 in here? This is one of the exceptions. OMB says a federal grantor agency must take into account risk in awarding money to your agency and to your agency and to your agency. And FTA responded, we can't apply any risk because we don't have any choice who we give 5307 monies to. It's dictated by formula and urbanized area status. We have no choice. We could deem them a high risk, bad risk grantee. We still have to give them money per apportionment formula. And so they took exception to that. They also took exception to the implementation date because the super circular went into effect December 26th, 2014. FTA recognizing that they have capital grants whose period of performance may stretch way too long, many years, didn't want you to play by 2 different sets of rules in the administration of any one grant. So FTA says, if you signed the contract with us on or before December 26th, you can manage that grant through its completion using the old rules. But if the contract was signed after December 26th, you have to play by the new rules in the super circular. So that may impact some of you with long-term capital grants. So again, if you see any reference in any of your literature and contract and the like that refer to A87, A122, the common rule, you probably ought to get your attorney involved because that material is out of date. So any questions about the background and who OMB is and why they're important to us? No questions, other than the state asking something about Title VI. Do we need more coffee, a little more caffeine? Get the blood flowing? Well, let's